on judiciary, civil, and criminal jurisprudence will come to order. Because we do not yet have a quorum present, we will go ahead and start off as a subcommittee. So first up is House Committee Substitute number 2 for House Bill 1886. Representative Veit, whenever you're ready.
Thank you, Mr. Chairman, members of the committee. My name is Rudy Veit. I'm a representative from the 59th District, which is part of Cole County and part of Jefferson City. I have before you House Bill 1886. And basically that bill arose last year already in Senate Bill 72 by Senator Curtis Trent. It was also carried, I think, this year here in this committee by Senator Curtis Trent on 897. And this bill, the only changes from this bill from last year would be that we did offer add the qualified spousal trust, which is just a mechanism so that when a tenancy by the entirety is placed in the trust, it doesn't lose its protection from creditors. And that is important because it's needed for our trust, and trusts serve a very useful purpose in avoiding future legal costs and estate planning. Another protection was when a parent has a child who's disabled, turns 18, we need to get a guardianship appointed. We're trying to eliminate some of the cost up front for the parents. It just allows a mechanism that they can at least get the proceedings started. Attorney is still appointed for the guardian. All safeguards are there. We took out one provision, which was a waiver of the background checks. Court could waive that. That was taken out because some people objected to it. But other than that, this is basically the bill that was here last year.
Questions for Representative Veit? Senator Schroer.
I'd be kicking myself if I left this committee and didn't give you trouble on the re-perfection House Committee Substitute number 2. Could you explain what happened there? I'm just curious.
Yes, I was over-optimistic and didn't cover all my dot my I's and cross my T's.
Okay. What was the problem with the
There was
first?
one problem with in the guardianship thing, we had taken out that a judge could waive the background study of a parent or grandparent that had the children for all this time. Some people wanted that, thought
Okay.
that we were leaving the child unprotected. There's a little bit of cleanup language that they wanted in the alternative dispute resolution, and that was they wanted to make sure there was nothing in here that's going to make it binding that you had to do it. We wanted it to be a voluntary service. The alternative dispute resolution is very important because we need to continuously make our judicial system more efficient and accommodating to people and keep down costs. It's like anything. If you don't keep changing, keep efficient, you're going to become obsolete.
Like Blockbuster.
Yeah.
Well, thank you for chipping away and getting this thing re-perfected.
Thank you.
Any other questions for Representative Veit? Seeing none. First witness in support of House Bill 1886.
Hello there. I am Jean Manicky. I'm counsel for the Missouri Press Association. Good to see all of you again. I'm here only for 537 to 529, that part of the bill. Last week I told you quite a bit, and I don't want to repeat what I told you last week, but I do want to tell you one story that I think will make this real clear. I know of a local candidate who filed for a local government race. She had an opponent, and that opponent was supported by a local community person that my client was very concerned about. And she sent out a flyer to the voters saying, I'm concerned about the relationship between my opponent and this other community member. The community member sued her for libel. The case was in court for 2 years. We could not get summary judgment, even though there was a tremendous amount of work done. Her legal fees were in the 5-figure range. Because we were going to have to go to trial, this particular client chose to settle the case. She wanted to get it over with. And the settlement was in that same kind of price range. The problem was there was no actual malice, but we couldn't appeal the denial of summary judgment. This will fix that problem. And that's a problem that any one of you could find yourself in a political race where you get sued. So this is important to the public, it's important to the media, it's important to political figures all over the state. Thank you.
Thank you. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support of House Bill 1886. Oh, we do have a quorum, so we're going to go ahead and take roll. Madam Secretary, would you please call the roll?
Senator Lukemeyer.
Here.
Schroer. Here. Coleman. Here. May. Roberts. Here. Thompson Rader. Trent.
We do have quorum. Proceed when ready, Professor.
Thank you, Mr. Chairman and members of the committee. My name is Paul Ladehoff, and I'm here as the co-chair of the ADR committee at the Missouri Bar Association. And I'm speaking in favor of House Bill 1886. As mediators are wont to do, we've spent several years in discussion, discernment on this adjustments and update to 4385 or 435.014, sorry. And have reached consensus in the mediation providers, mediation users. The updates proposed, as Representative Veit mentioned, include definitions to clarify the process and important characteristics of the process like confidentiality and the limits of confidentiality, as well as procedures to ensure mediator neutrality, impartiality, no conflicts of interest, those kind of things. The existing statute was adjusted in 1986, and of course mediation has grown exponentially since then. We've learned a lot about the process. There have been other organizations like the American Bar Association and others that have adopted ethical guidelines, those kinds of things. We've incorporated that learning into this proposed statute. So we're wanting to replace 435.014 with these provisions. And with that, I'll entertain any questions that I can help with.
Any questions for the witness? Seeing none, thank you for your testimony. Senator Trent has graced us with his presence. I would now make a motion that we go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are in executive session. I would now make a motion that we bring before the committee for consideration Senate Bill 897. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee. This is Senator Trent's beautiful omnibus bill that I believe we have scoped back. There's a Senate committee sub that has been distributed to the members, and I will kick it over to Senator Trent for any explanation.
Well, that might be a short explanation. I think there's a pretty good tracking document that's been distributed here that everyone can look through. The language that dealt with the foreign sponsorship of lawsuits has been removed. And I believe there was a couple others maybe that a couple other committee members wanted. But the tracking document, I think, does a pretty good job of showing the particulars of what has remained in. So if anyone has any specific questions, I'd be happy to try to answer those.
Any questions for bill sponsor? Senator Coleman.
I actually just wanted to thank the bill sponsor for working with me on tracking down the provisions I had questions about when the bill was presented, and those have been satisfactorily answered. So thank you to the chairman and this bill handler.
Any further discussion? Hearing none, I'm going to make a motion that we adopt Senate Committee Substitute for Senate Bill 897. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. You adopt the Senate Committee Substitute. I now make a motion that we vote do pass Senate Committee Substitute for Senate Bill 897. Do you have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Lukemeyer.
Aye.
Schroer. Aye. Coleman. Aye. May. Roberts.
Aye.
Thompson Rader. Trent.
By your vote of 6-0, you have voted do pass Senate Committee Substitute for Senate Bill 897. Now make a motion to bring before the committee Senate Bill 1440. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. Bill is before the committee. for the benefit of the committee, this was Senator Ben Brown's bill that we heard last week. It updates some notary requirements for business records affidavits to make electronic signatures permissible. And then it increases the penalty for disclosing personally identifiable information for public safety officers. And so this is an anti-doxing provision. And if there is no other discussion, let me ask, is there any discussion on the bill? Seeing none, I would make a motion that we adopt the Senate committee substitute, which was previously distributed to the members of the committee. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You've adopted Senate committee substitute for Senate Bill 1440. I would now make a motion that we vote do pass Senate committee substitute for Senate Bill 1440. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Lukemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Raider. Trent.
By your vote of 6-0, you have voted do pass Senate committee substitute for Senate Bill 1440. Now make a motion that we bring before the committee House Bills 1692 and 1748. Do you have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. The bill is before the committee, and I'm going to turn it over to Senator Schroer as the Senate handler of the bills.
Yeah, typically when we pass something in one chamber and it's changed in the other chamber, we get what is known as the pink sheet. So the pink sheet was distributed saying, well, we've got an issue here, resolve that so there's no conflict once it goes to the governor's desk. And ultimately, this is getting us in line with what we have passed out of the Senate several times this year. So with that, I would be open to any questions. This is Valentine's Law.
1692. So the Senate committee sub that we're getting ready to vote on, as Senator Schroer said, all it does is it makes consistent with what we passed previously out of the Senate. So we don't have a conflict between the two versions. So any discussion on the Senate committee substitute? Seeing none, I would now make a motion that we adopt Senate committee substitute for House Bills 1692 and 748. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You've adopted the Senate committee substitute. I would now make a motion that we vote do pass Senate committee substitute for House Bills 1692 and 748. Do you have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Lukemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Raider. Trent.
By your vote of 6-0, you have voted do pass Senate committee substitute for House Bills 1692 and 1748. I would now make a motion that we exit executive session. Do I have a second? It's been moved and seconded. We are out of executive session. We are back on witnesses in support for House Committee Substitute number 2 for House Bill 1886. Whenever you're ready.
Mr. Chairman, members of the committee, my name is Andy Briscoe. I'm the registered lobbyist for the Missouri Bar. We'd like to go on record supporting this proposal.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support.
Good afternoon. My name is Locke Thompson, Cole County prosecutor here for the Missouri Association of Prosecuting Attorneys. We would just like to go on record in support of this bill, particularly a couple of provisions which I know I've been here testifying on other bills. The 491, 492 fixes access to probation and parole records and adding victims of Class E felonies to the Crime Victims Compensation Fund. So, happy to answer any questions.
Any questions for Mr. Thompson? Seeing none, thank you for your testimony. Further witnesses in support.
Mr. Chairman, members of the committee, my name is Marcia Hazelhorse. I'm the Executive Director of Missouri Juvenile Justice Association, and we just want to go on record as supporting House Bill 1886.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support.
Good afternoon, Mr. Chairman. For the record, James Harris, here to testify in support of House Bill 1866 on behalf of the Institute for Free Speech, specifically the anti-SLAPP wording that was mentioned earlier in section 537.529. Happy to answer any questions.
Any questions for Mr. Harris? Seeing none, thank you for your testimony. Further witnesses in support?
Good afternoon, Mr. Chairman, members of the committee. I'm Heath Clarkston, and on behalf of the Missouri Broadcasters Association, in support of the bill for the same reasons as the last witness.
Any questions for Mr. Clarkston? Seeing none, thank you for your
Lock chairs.
testimony. Further witnesses in support?
Chair, members of the committee, Jessica Petrie here for the Missouri Network Against Child Abuse, formerly Missouri Kids First. You all have heard us testify in support of the 491 and 492 provisions multiple times, and just want to go on record in support of those again.
Any questions for Ms. Petrie? Seeing none, thank you for your testimony. Further witnesses in support?
Senators David Claridge today appearing on behalf of, in favor of 1886 on behalf of Reisman Berger, specifically with regard to 456-950, the qualified spousal trust provision.
Any questions for Mr. Claridge? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chair, members of the committee, Eric Jennings, Government Relations Counsel at the Supreme Court, here to testify in favor of House Bill 1886, particularly the orders of protection, raise the age, fixes, and juror compensation.
Okay. Any questions for Mr. Jennings? Seeing none, thank you for your testimony. Further witnesses in support? Any further witnesses in support? Seeing none, any witnesses for opposition? Any witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on House Committee Substitute Number 2 for House Bill 1886. Next up, House Committee Substitute for House Bill 2064, Representative Black, whenever you're ready.
Thank you, Mr. Chair, members of the committee. John Black, House District 129, Webster County, Missouri. Thank you for letting me testify on this bill. The lead bill 2064 is to include mental health courts in treatment court divisions. This is a recommendation of the Statutory Task Force on Substance Abuse Prevention Treatment, which Senator Shores vice chair, Senator Luke Myers member. That is one of the 18 provisions in this bill, Mr. Chair. Majority of these bills passed the House last year. Other provisions with which you probably are familiar are provisions with regard to electronic wills and electronic estate planning documents, provision on Uniform Interstate Depositions and Discovery Act, provision with regard to jury pay, which we've heard about before. It includes the provision on ADR, the amended version, which previous witness testified with regard to. Be happy to answer any questions, Mr. Chair.
Thank you. Any questions for Representative Black? Seeing none. First witness in support.
Thank you.
For House Bill 2064. First witness in support. And by the way, I realize that there is a significant amount of overlap between this and the last bill, so if your testimony is the same as it would have been for the last bill, just saying "me too" again is perfectly sufficient for the committee.
Me too.
Thank you. Any questions for the witness? Seeing none. Further witnesses in support.
Well, I would say me too, but I want to add something that wasn't brought up on the last one. I'm Jean Manicky. I'm the attorney for the Missouri Press Association. I have a visual that I will be happy to send to Representative Black to forward to the committee if that is appropriate. But there are cases now being filed in CaseNet where the entire pleading that is filed on CaseNet is blacked out, and there's no information being made public. This bill, in particular the provisions in 509, 520, will help lawyers all across the state solve the problem they're having with what information should be redacted and what's not. That's all I have to say. Thank you.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support.
Senators David Claridge, again, appearing on behalf of Reisman Berger in favor of 2064. We omitted as part of the estate planning section the qualified spousal trust for 456-950. Would you please add that? Thank you very much.
It will be added.
Thank you.
Any questions for David? For David? No questions. Seeing none, thank you for your testimony. Further witnesses in support.
Good afternoon again. Locke Thompson with the Missouri Association of Prosecuting Attorneys, going on record in support of this bill.
Okay, thank you for your testimony. Further witnesses in support.
Thank you, Mr. Chairman. Mark Rhodes here on behalf of the legal aid organizations of Missouri. We support the bill, but we are particularly in support of the inclusion of 477-650, which repeals the sunset clause on the Basic Civil Legal Services Fund. Thank you.
Any questions for Mr. Rhodes? Seeing none, thank you for your testimony. Further witnesses in support.
Mr. Chairman, members of the committee, Paul Ladehoff, co-chair of the Missouri Bar ADR Committee, just want to confirm our support for this bill, the ADR provisions.
Okay, thank you for your testimony. Further witnesses in support.
Mr. Chairman, members of the committee, thank you. Logan Hobbs, Legislative Liaison for the Department of Labor and Industrial Relations, specifically for this bill, the administrative law judge provisions and the oversight measures put in place there. That is the department proposal. I want to come out in support of that and answer any questions as to that deal, how it was arrived, or any questions regarding that oversight process currently or in the bill.
Just one quick question. I know
Yes,
that
sir.
we've heard Senator Schroer's companion bill in the committee. I know that he presented originally on an initial file bill. There was a compromise that was reached. We voted out a Senate committee substitute. The language that we have in Representative Black's bill, is that identical to what the Senate committee voted out, or are there some variances?
It is identical in substance. There were very minor drafting, like just wording changes in there, and that was, but substantively it is identical.
Okay.
So
I guess if there were small technical changes, does the department have a position on the Senate committee version versus the House perfected version in the bill?
either version, when we viewed it to provide fiscal analysis, accomplishes the same things, and we have no issues with either of the wording. It's truly just like the order of words and sentences. So.
Okay, perfect. Any further questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chairman, members of the committee, Ray McCarty, Associated Industries, Missouri, want to go on record in support of the ALJ reforms as well as the ex-offender employer protections.
Any questions for Mr. McCarty? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chair, members of the committee, Heidi Geist-Bueller-Sutherland here on behalf of the Missouri Chamber of Commerce and Industry in support of the two provisions that Ray just mentioned, the ALJ provisions and the civil liability for employers hiring ex-offenders.
Perfect. Any questions for Heidi? Seeing none, thank you for your testimony. Further witnesses in support?
Mr. Chair, committee members, Eric Jennings, Supreme Court Government Relations Counsel, testifying in favor of House Bill 2064 with respect to the juror compensation provisions, the 509-520 confidential information of court records that Ms. Manicki had mentioned, the underlying mental health treatment courts, and I believe that's all on this one.
Great. Any questions for Eric? Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any witnesses in opposition?
Thank you, Mr. Chairman, and the committee. I can't talk nearly as fast as you do, but I'm going to try to get my points across. I'm only here to testify in opposition to 537-580, which is the Ex-Offenders Act. I'm a lawyer from St. Louis. I represent victims of violent crime, and I'm a past mentor with Mission St. Louis, which is as a nonprofit with the goal of putting ex-offenders back to work and making them productive members of society. The problem with this section of this bill, and I support the proposition. I support the proposition, people who've paid their dues to society, getting back and being productive members, and employers being given some guidance when they may be reticent to hire ex-offenders of any type. But what this bill will allow, it'll put the community in danger. It allows employers to knowingly hire sex traffickers, pedophiles, and others from out-of-state or federal convictions for such crimes to work freely as camp counselors, in candy shops, and things of that nature where they're not appropriate. It will allow people who have multiple convictions for drunk driving to drive school buses, and it will protect employers who hire them from negligent hiring lawsuits. I know this wasn't the intent of the bill, but the way it's framed, the way it's written, it's only looking at Missouri convictions. So a city like St. Louis or Kansas City or Springfield may be hiring people from Illinois. And the guidance that you'd be able to give as your lawyer for a company is you don't have to look past Missouri, all right? So you could hire an ex-sex offender from Illinois or a federally convicted sex trafficker to work at your motel as a motel manager, and basically turn a blind eye if they convert that hotel into sex trafficking central. I support the proposition behind, or the idea behind this, but when you're talking about employment, some jobs require different scrutiny than others. So working in a lumber yard, working in a factory might require different due diligence in looking into backgrounds than putting people to work at Veta Soccer or in daycares or driving a school bus. So I think it needs to be reworked. I think with the variety of employers out there, each type of employment requires different due diligence. So I'm happy to answer any questions and explain how I've reached these conclusions, but I think it's pretty clear on the face of the bill that this is, it needs work.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in opposition? Witnesses in opposition? Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on House Bill 2064. And before we move on to 2700, just for the benefit of the two members of the committee that are still here, we will likely be scheduling an executive session later in the week to vote out a committee sub on the last two bills that we heard, which will likely get put together in a committee substitute. So we're getting to that point in session where time is precious, and so in an effort to advance these along as quickly as we can, the hope would be to meet one more time this week just for the purpose of an executive session on those two bills. With that, next up is House Committee Substitute for House Bill 2700. Representative Copeland.
Thank you, Mr. Chair. Thank you, committee member. And I just want to go through and just thank everybody for this bill. This is a comprehensive criminal proceedings bill. I don't know what the word omnibus bill, this is a comprehensive bill here. So, and basically you probably heard many of these things on here. I think they're on several of the bills that you guys already heard. This is just something that got put together in the House that kind of added a few more good things I think that would help our criminal justice system going forward. Basically, we got one for selling of Schedule 1 and 2 enhancement for bodily and death. I think you guys already have something like that over here that you've heard. Got a little bit different language, but it's similar in the bill. It has some juvenile changes. I think you have some of that over here, changes the juvenile, some of the juvenile ages from 12 to 14. Some other things about how they can be housed as in a juvenile in an adult facility. There's some jail reimbursement issues that it says can be paid up to. It doesn't demand the payment to be there. We got some line of duty deaths. I think looking at the line of duty deaths for emergency personnel is outdated. Currently I think it's $25,000 for an line of duty death. I think sometimes we need to look at the inflation rate and what's going on in the society to take care of their people who got here and put their lives in danger to keep us secure. There's DWI diversion programs for interlocking devices, some of that there. Also in this, there's mental health courts, and I think you have some of that in the last bill that you talked about. I think that's some good updates. There's just a lot of good little things in here. There's also some modernization, some records for allowing some electronic signatures. Nowadays you can allow them. It's just kind of difficult. Used to you had to do it in person. This allows for some of that to happen. Gives the dangerous felony for endangering the welfare. If you're actually producing fentanyl with children involved, it kind of ups that sentence, gives them a little bit more of a sentence if you're doing that in front of children. There's also one here that offense used with a minor to commit a crime. I think they're seeing some issues in some of these places where they're using the minor to commit the crime, and they're getting away with some crimes, and they're going to juvenile court. So that kind of gives something, a little bit of bite to the person using the minor if you can prove. Now, this is all you have to prove as well. Valentine law is on here, and I think you're correct. I got a pink slip on that. Our language doesn't match your language. I don't have no problem if however you want to move this forward. I definitely want our language to match what you have over here, so at least it can go forward. That's not an issue I have. There's also tampering with an electronic monitoring device. I didn't know you couldn't be charged if you let the battery die. I guess if they let the battery die, they're getting away with some of that. And I think on here, the public defender, I think you have that as well. It's a fund that allows the public defender to get some funding. Now they're not allowed to if it's a donation through grants. That's just another way of doing that. There's other things on here. I can answer as many questions as you wish, if you have any questions.
Any questions for the sponsor? Seeing none.
Thank you
First
very
guest in favor, please come forward. I thought the judge was going to come forward. I would allow it, but.
He would, too.
Good afternoon again. Locke Thompson for the Missouri Prosecutors Association. I know I've been here a number of times testifying on a lot of the provisions included in this bill. We think it is a great comprehensive crime bill.
Thank you again for your testimony and support. Any questions? Seeing none, on to the next witness in favor. Please come forward. Make sure you have a witness form and proceed when ready.
Good afternoon, Mr. Chairman, members of the committee. My name is Marcia Hazelhorse, and I'm the Executive Director of Missouri Juvenile Justice Association. And like other witnesses, we have testified previously in front of this committee on juvenile-related issues, particularly around certification. This bill changes the minimum age for permissive certification hearings from 12 to 14, and then establishes a minimum age for mandatory certifications to age 12. It also addresses some issues related to youth in detention. Current legislation allows for a juvenile who's committed a misdemeanor traffic offense to be placed in juvenile detention for a misdemeanor. The juvenile court does not have jurisdiction over children 15 and older who've committed a traffic offense. That's the Court of General Jurisdiction. The only jurisdiction the juvenile officer has over traffic offenses is when it's a felony, and those children would likely go to detention. So it just removes a provision in 211-033 as well as 221-044 that allows the traffic court judge to request the child be placed into juvenile detention. I think this will significantly help issues around detention in the state of Missouri. We have 18 juvenile detention facilities for the entire state. We currently have many challenges with the youth that we have currently in detention who've committed serious felony offenses, and we just don't see the need to be putting a child who's committed a misdemeanor in juvenile detention with the significant challenges we currently face in our juvenile detention facilities. It also has a technical fix to the certification statute by allowing the language of motion to modify be added. Currently, the juvenile officer is able to file a motion to modify when a young person has already been on supervision, violates supervision by committing a new delinquent act. And it is something that certification is being requested. So we also have case law out of the Southern District of Appeals, Missouri Court of Appeals Southern District, that basically said that the label of a filing does not prejudice the juvenile. In motion to modify is an appropriate term that can be used, so that's really just mirroring current case law. And then we also have some cleanup in this bill with respect to holding certified youth in detention. Currently, those youth automatically remain in juvenile detention facilities until they turn age 18 or until there's a conviction on their adult charge, whichever comes first, or if the court decides to hold a hearing and the judge finds in the interest of justice that child should be moved from juvenile detention to the jail. So we're asking for, in those cases where the judge has held a hearing, found that it's in the interest of justice to move this young person from the juvenile detention facility to the jail, that if that young person bonds out of jail and commits, has some type of violation of their bond condition, that they go back to jail rather than coming back to juvenile detention and then having to have that hearing all over again. And then it also asks for a liaison with the jail administrator, sheriff's department, someone that would be in charge of that juvenile or that adult case for when the young person is still sitting in our juvenile detention facilities. They've been certified as an adult. The juvenile court has no jurisdiction over them. We're simply the place that holds them pending the adult charges. And so we'd like to have a liaison appointed to really improve communication between the juvenile officer and the jail in terms of hearings, transportation, and things of that nature. And then one cleanup from when we raised the age of juvenile court jurisdiction, we changed the age of commitment to Division of Youth Services to age 19, which makes perfect sense. And we changed that in Chapter 211, but we missed changing it in Chapter 219, which is Division of Youth Services statute. So the change to 219 021 is just merely a cleanup, mirroring what's already in Chapter 211. And then we also have 221-044, some changes there by removing the allowance for a juvenile who's committed a traffic offense to be placed in juvenile detention, as well as it also gives the juvenile officer the authority to file a motion and ask the judge to move a young person who has turned 18 years of age while in juvenile detention. They're on juvenile charges, but they've already turned 18 and maybe likely not being very compliant in the detention facility. So it allows for the juvenile officer to file a motion asking the judge to hold a hearing to determine if that young person should be moved from detention over to the jail. This is not a mandatory. This is a case-by-case basis and likely would only be done, like I said, when that juvenile is not compliant with the juvenile detention rules. And then the final change is just allowing the juvenile officer in some areas of the state, the juvenile officer is allowed to carry a firearm. That's with permission of their presiding judge as well as their juvenile officer. And they follow very specific policy and procedures around that and have training requirements. And this would allow them to have that exception to have the carry and conceal portion. And I'm happy to answer any questions.
Any question from the remaining member? None. Thank you for your time and your support on this bill. Any other witnesses in support of House Bill number 2700?
Jessica Petrie here again on behalf of the Missouri Network Against Child Abuse, just going on record in support of the 491 and 492 provisions again.
Any questions? Seeing none. Next witness in support.
Mr. Chair, member of the committee, Eric Jennings, on behalf of the Judicial Conference, in favor of the juror compensation, the mental health treatment courts, and the tampering offenses with the judicial officer and judicial proceeding.
Very well. Any questions? Seeing none. Keep thinking she's going to have a question, but you guys are doing so well. Next witness in support. Seeing none. Any witnesses against? Make sure you've got your witness form and proceed when ready.
Thank you all for having me. TJ Kirsch, Missouri Association of Criminal Defense Lawyers. In opposition, a few quick notes. I note the change to 43650, a violent offender registry. I understand how this bill defines violent offenders now by my reading, just as people who are subsequent to conviction on murder charges, from what I can tell. I would just caution against expanding registration. I know you've heard lots of testimony on other bills about the efficacy of registration in the first place, but I strongly suspect that list will grow. It will be another registry that does not do what it intends to do, and I am confident that more convictions will land more people on such a registry. As it is now, I understand that it's limited, but I suspect it'll grow. Primarily the reason I'm here are the changes to 579020. That's the portion dealing with delivery of a controlled substance. It enhances delivery of a controlled substance if serious physical injury or death results. And I cannot emphasize enough the poor incentives that statute creates without also adding delivery to 195-205, which is the immunity from prosecution statute. I won't belabor the point, but I feel my experience as a defense attorney is relevant to the committee's consideration of the bill. I practiced in a county that began charging overdose deaths as felony murder. Shortly thereafter, 2 of my clients were found dead in a ditch. On separate occasions, I should be clear. Bills like this, I trust the idea is to go after the drug dealers. You never get that high up the chain. Users use together, people overdose around their friends. Their friends then face a felony prosecution, knowing that if they take their friend to the hospital, there is no immunity from prosecution. The incentive is, I'm sure, not what this committee intends. The law of unintended consequences acts very powerfully in something like this. When people, again, people who use together know that their choices are take a friend to the hospital, where we have Narcan widely available these days, or try to get out of there and cover their tracks. Obviously, none of it's behavior that is to be condoned, but it is behavior we will see, we already see, and will continue to see with incentives like this. Thank you, and I welcome any questions. I'm not sure if I wait or stand up.
Yeah. So we're on page 57 on 579020, and we're just discussing up here as what happens when you only have 2 members present. But it says knowingly distributes or delivers a Schedule 1 or Schedule 2 controlled substance and serious physical injury or death results. So that would encompass marijuana, correct?
That would.
And knowingly distributes, if you know that you distributed marijuana, but you didn't know that it's laced with fentanyl and someone dies, or is it your assertion that they would be under this new language?
Yes. And the reason I can answer that confidently is the case law is pretty clear. In order to sustain a controlled substance offense conviction in Missouri, the defendant need not know what the controlled substance was. So, for example, we have cases where client is arrested. That client might think what they have is methamphetamine, for example. The lab results come back cocaine, not methamphetamine. That's not a defense at trial, and that's a conviction that will be affirmed because it's whether or not you knew you had a controlled substance. They do not look to whether or not you know which controlled substance you had.
Good point. Any other questions? Seeing none, thank you for your testimony. We look forward to working with you on amending some of these provisions. Any other witnesses against the House Bill 2700? Seeing none. Any for informational purposes? Seeing none. Any closing remarks from the representative? He's good. With that ends the public hearing on House Bill number 2700. Having no further business before the committee, I make a motion that we adjourn. Seconded. All in favor say aye. Aye. All against say no. We're done.